Hello, everybody. Welcome to Chatting with Charlie by WR Immigration, our EB-5 Investor Outlook for September 2025. My name is Joey Barnett. I'm a partner at WR Immigration. I specialize in EB-5, and thank you so much for tuning in. We're having a number of people join us live. If you're listening to us on YouTube, thank you so very much. And we are got a lot of good questions coming into us. We're also having the chat available. So if you have questions about what we're talking about today, please feel free to do it. And of course, we're here, you're all here, and you're listening not because of me, but because of Charlie Oppenheim, who used to work for the State Department. Charlie, how long did you write the Visa Bulletin?
Probably 23 years doing the visa bulletin and making the decisions, and total about 43 years with the State Department.
So that's an incredible amount of experience. No one has the insight that Charlie has, which is why we are so happy to have him on the show. I'm so honored to get to do this uh, podcast thing with him every month. And again, my name's Joey Barnett, and I practice in Los Angeles in EB-5. WR Immigration is a full service immigration law firm. We're considered one of the top EB-5 law firms. I think we file more cases than anybody. Well, at least we're the top three, I would think. And we'd be happy to help you or your family get EB-5 green cards. This doesn't constitute legal advice. It's for informational purposes, but feel free to reach out to us. Here is the email below. My email will be later. And I just want to kind of get through some of these intro slides to our roadmap for today. Okay, so September 2025, it's the last month of fiscal year 2025. Um, and fiscal year 2025, has it been a good year for EB-5 in fiscal year 2025, Charlie? What are your thoughts?
I think overall, yes. For the reserved categories, they've remained current. Unfortunately, the amount of number use for reserved is very minimal. It is almost unconscionable how few reserve numbers have been used this year in relation to the amount of filings, which is a very unfortunate chain of events.
Right. So there's a lot of demand for EB-5. We're filing cases every day. There's been billions of dollars of EB-5 investment capital, thousands of EB-5 petitions filed. And it doesn't seem like to date that the State Department is putting too much resources into issuing those immigrant visas. USCIS can only adjudicate adjustment of status applications after the I-526 is approved. We're hoping that picks up in the coming month because there's a whole host of approved I-526s with people with pending adjustments that are waiting for approvals. And if they don't use the numbers this year in the next month or so, that's going to make this problem even worse for EB-5 investors moving forward. So I would say for unreserved EB-5, it was actually a very good year, right? They using probably all of the unreserved numbers, I would imagine, just like they have for the past few years. Isn't that right, Charlie?
Yeah, unreserved, it's been very good. As you said, the additional reserve numbers that from previous years that were added to unreserved has helped diminish those waiting lists. Uh, and again, I think for fiscal 2026, the unreserved categories will have a very high annual limit because of the fact that the reserve numbers from fiscal 2024, which carried over for potential 25 use, most of those will not be used. Therefore, they fall to unreserved in fiscal 2026. And again, the fact that we're wasting thousands of numbers each year really is going to exacerbate the problem with the final action dates whenever they're imposed in the future.
And we're kind of jumping ahead a little bit, but it's so timely to talk about is that there's just a lot of things that we don't have the data on. For example, all we know about in terms of fiscal year 2025 visa use right now is from the State Department. And what we know is that through the end of May, there's only been 568 reserve visa numbers used. There's thousands available. We don't know how many adjustment of status applications have been approved in the reserve categories this year. That comes out later. And so we're kind of operating in the dark, but that does really impact backlog times. Wouldn't you say, Charlie?
Yes, it's going to have really have a negative impact in the future.
So we're going to be talking about that a bit more. We're going to be talking about what to expect in fiscal year 2026. And we're going to end it with potential final action dates for the reserve categories. Are they going to happen in fiscal year 2026? Stay tuned. All right. So this is the Visa Bulletin for September 2025. There's a couple of items here that I want to mention. The first, though, is all of these C's. Charlie, what does that mean if there's a C for uh, these EB-5 set aside categories?
That indicates that the category is considered to be current, meaning there are sufficient numbers available for immediate action to issue a visa or process a green card for any applicant who has an approved reserved preference category.
Oh, I'm so glad. That was a great way of saying it because you said approved. It's not related to pending, it's approved. And so there's this thing called the invisible backlog. I tell every EB-5 investor about it. It's based on the number of cases that are pending at USCIS. We know there's sufficient amount of demand by Chinese and Indian nationals that, if and when approved, will take up the foreseeable years of supply worth of visas. And so that's why Charlie's insights here and sort of understanding, how long that may be and what are the factors and the numbers to get into it will help people understand and guide and make their EB-5 decisions. The other thing I wanted to mention was this U in the fourth category, and there was this note in the September Visa Bulletin that says, well, if at any time an annual limit where it would be necessary to make it unavailable, then they're not going to use any more numbers. And so my first question, because this is an EB-5 discussion, is Charlie, do you think there will be a unavailable numbers for anybody do you think we're going to see a U at any point in the next 5 weeks?
No, for the unreserved potentially, if they were to maximize number use in the next, say, 5 weeks, that is a great unknown. Unfortunately, we haven't seen any data on overseas number use posted since May, so it's hard to tell what processing is like. But I would not expect them to make an announcement that the categories that China or India is unavailable. I think those will remain processed through the end of September.
Okay, so this is fiscal year 2025 ending. These set aside categories have remained current since they were formed 3 years ago. And as Charlie mentioned, that means that anybody with an approved I-526 should be able to get their green card, whether through adjustment of status or consular processing. That's assuming, of course, that the government will be completing those processes. And that's sort of the big question mark is, are they doing it fast enough? And my answer is no, they're not.
One other thing that's important to mention is when the State Department announces these final action dates. This September bulletin the determination was made in early August. So these dates represent the best information they had at that time. So something could happen in August or September to change. Hopefully it's unlikely. In the reserved categories, they're definitely going to stay current. Unreserved, I think they'll stay the way they are. But again, as you mentioned earlier, It's not these dates that are important when you're filing your petitions. It's when your case is ready for final action, whether that's 2 months down the road or 2 years down the road. The dates which are in effect at that time govern whether your case can be finalized or not.
Right. And the discussion that I'm having with a lot of folks in the United States is, well, can we beat this backlog? Right? Can I file my case and get the I-526 approved and potentially even the adjustment approved before there's a final action date? And that's also a big unknown, and people are being very aggressive about it because they see the invisible backlog. They're filing mandamus lawsuits, because of it, and, some are having success. So, it's definitely a bold posture, but some people are doing it, and, they're it sort of goes to show, and actually we're gonna get into that a little bit, but it's not really, with these I-526 processings, it's not first in, first out. Right? And because it's not first in, first out, that really messes with our ability to predict when a visa may be available for somebody who's filing on a certain date. Because if it's all over the place, then, there's no rule of reason. How are we supposed to advise? Um, so Charlie, I kind of stole your point on that, but do you want to expand on that at all?
Well, yeah, and one real quick thing, before I do that, you mentioned with this, people making the decisions. The people that are in the US are at a great advantage because if they're able to file concurrently, they basically can get the benefits of a green card, even if their case is, if a future final action date is imposed, even if it takes several years for their case to finally come to final action, they're in the US and they've got that concurrent filing status benefits. So that's a very huge consideration for people going forward. But as you mentioned, one of the things in most of the other preference categories, say for the China or India second or third preference categories, there's such a long backlog waiting list of approved petitions. It's fairly easy to make predictions on when the dates will move and by how much. Unfortunately, there is no historical data in terms of the reserve processing. They seem to be processing, all over the place. A case that was filed in January may be still pending, but one that was filed in June may have already been approved. So as you said, that not knowing if things can be processed in priority date order, first in, first out order, et cetera, there's so many unknowns, which makes it extremely difficult to make predictions of what's going to happen in the future with reserved and at what point in time.
Right. And let's move forward on our slides here. So here's a question that we're getting. The October visa bulletin is going to be coming out in, I don't know, a few weeks or so. What can we expect for EB-5 in the October visa bulletin?
I think EB-5 reserved will be current for both October and November. I see no legal reason why a date would be opposed earlier than December at the very earliest. Uh, so the reason being is a final action date should only be imposed when the number use to that point in the year plus the expected number use in the current and upcoming month will exceed the allowable amount in that period. They're going to be announcing the October dates in early September. So no numbers will have been used in October, meaning everything has to stay current and reserved. They'll make the determination of the November final action dates and announce that bulletin in early October. Again, no numbers in large amounts would have been used yet. So therefore, that is why I'm saying both in the October and November visa bulletins, all of the reserve categories will be listed as current.
Right. And even assuming, let's just say there were 500 EB-5 I-526 approvals tomorrow. That doesn't mean that those visa numbers are going to be used in fiscal year 2025. In fact, they probably won't be used in fiscal year 2025 because there's that second step, whether it's the adjustment of status or the consular processing. And that's actually the kind of the first question that we got here is when is a visa number used? Is it when the I-526E is approved or when the I-485 is approved? Charlie?
The number is used only at the time of final action on the case. So, for example, will you stick to adjustment of status processing? If Joey is interviewing me for my rural reserved preference category today, he finds me eligible. He will type my information into his computer, my priority date, my visa category, my foreign state. He'll press a button and he'll get an instantaneous response that either the case has been approved if everything's within the applicable final action date, or it'll go into pending. So that's when a number is used, not when the petition is filed, not when the petition is approved, only when all required processing has been completed and the case is ready at the end of the interview for either the adjustment of status to occur or a visa to be issued if processing overseas.
Which is why we need USCIS to pick up the processing at IPO of the EB-5 petitions, but as well at the California Service Center with the adjustment of status applications. We have seen the data that we have on approvals through January of 2025. There's 1,126 rural approvals, 351 high unemployment area approvals. So we had always kind of so I guess what does that sort of signal to you, Charlie, in terms of which category, reserve category may have a final action date first, high unemployment or rural? And we've kind of always assumed because rural has double the number of visas that high unemployment with equal demand would get the final action date first. But that may be changing based on what USCIS processing is happening, right?
Yeah, I think so. As you said, originally, I thought because of the sheer volume of high unemployment petitions being filed in relation to those for rural, I assumed that the Immigration Service was going to be essentially processing the cases in a first in, first out basis. But is not happening. So it kind of threw the old logic out the window. And as you said, even though that the rural category has a double the annual limit. And so they've got more numbers and they have fewer petitions having been filed. I do believe the rural is more likely to have a final action date imposed earlier than high unemployment.
Yeah. Here's a good question. Will the travel ban impact EB-5 visa numbers used? So the travel ban doesn't prevent the issuance of visas. At least that's what you argue in court. But they pretty much will have stopped issuing visas to people who are from countries of the travel ban. So probably yes, it will impact. You could litigate that. You could potentially get the immigrant visa in your passport, but then the travel ban would prevent you from using it unless you were otherwise like eligible for a waiver or an exemption. So that's a question by someone. What happens to aging out children who need to go through consular processing? Well, this is the big issue with these visa backlogs is that the Child Status Protection Act only counts the time in which the I-526 is pending when you're subtracting the child's age when a visa is available. And if a visa isn't available because there's backlogs, then yes, there could be age out issues for children who are going through consular processing. So that is a question there. With adjustment of status, it's much more, well, it's more of an open question on adjustment of status, and we can get into that a different time. But certainly for consular processing, that is the case. Okay, so Charlie, on this slide, what are we assuming here? They have, because I don't think they've told us the annual limit for fiscal year 2026, right?
No, they won't know that until probably about late October, early November at the earliest, although they can make estimates earlier. But for the sake of this chart, I just assumed that the annual limit for fiscal 2026 will be approximately the same as it was for 2025, that being approximately 150,000. Even if the overall employment limit were several thousand less, it only would impact these calculations by maybe a couple hundred. So it's not, statistically important. But again, we had in the rural for fiscal 2025, there were 2,131 numbers available for use under the initial limit. Plus, we had the 2024 carryover. So those unused numbers would carry over to the 2026 limit, with any minimal use of the 2025 reserve being reduced. But again, you carry the carryover plus the original limit equals 4,262 on the high unemployment. Last year's 1,065 limit added again, that results in the 2130. But again, you see the limit is relatively low. The government needs to be maximizing number use in these categories.
And we're going to get more into how they're going to look at the supply and the demand, because it's done really on a quarterly basis, right?
Yes.
Right. So that's what it says on the bottom of this slide. I wanted to put this in here because these are the new EB-5 visa categories, and I just see these new classifications and codes come up on approval notices. And I just wanted to put it up there because there's so many of them. And it's different for the State Department, and USCIS. And the thing that is really bothersome is we're starting to get reserved visa appointments at consulates abroad, which is great to see, but they're not using the right code. They're still using the old codes. I-5, T-5, R5, it's they haven't updated it, but they're requiring folks to put the code in, right? And so there's been some back and forth with the consulates about that. But anyway, I just wanted to show that these are what the codes are that I have seen. I don't know, Charlie, what's your thoughts about these kind of old codes versus new codes?
It's just they shouldn't, they should have fixed it on the state side. They shouldn't be requiring the applicant to tell them what to do. It's very unfortunate, and that causes potential delay in processing time. That's something that should have been caught at the National Visa Center stage, because this National Visa Center is supposed to be sending, cases that are ready to go to the post, and the correct classification should be listed.
Right. And you elect it with NVC. So NVC should then send that to the consulate, and the consulate should know the correct code, not the old code.
Right.
All right. Okay. Next up. Okay. So we wanted to talk about a worst case scenario in the unreserved. We're kind of jumping all over the place today, but that's okay. I guess I got some of these all over, out of order. But can you kind of give us a breakdown of what you're seeing here in this worst case example? And I think it's sort of worst case for the Chinese nationals who have been stuck in the visa backlog for so many years.
Right. I would like to start out by saying, one, in my second figure, unfortunately, we do not have any information from the State Department. The most recent that they've released was from May of 2024. IIUSA requested that they update the list for a conference in 2025, which would have been extremely useful. The State Department denied the request. So again, we're having to rely on almost 2-year-old data. But again, what we do there's called otherwise unused numbers. And what you do is you start out with the annual limit. So the unreserved limit is estimated for 2026 is estimated to be approximately 11,500. It is estimated that there will still be approximately 3,500 applicants in the rest of the world with unreserved petitions pending that need to be processed. If we assume, which should be a reasonable assumption, that 100% of those applicants rest of the world will be processed during fiscal 2026, then we also subtract the China and India per country limit combined. So China and India will be subject to a 7% limit, which is 805 numbers. So you combine those, you get 1610. We know that China and India have enough demand. We'll use it. So you subtract that out. And that means that under the 11,500 limit, there is estimated to be approximately 6,390 unused numbers under that original annual limit. Those numbers can be provided to any country, would be India and China, which has hit their per country limit. And those numbers are provided strictly in priority date order, meaning they would all go to Chinese applicants, which would be a tremendous benefit in reducing the China unreserved backlog.
Thank you for that. And so also the thought being that there could even be more if we knew that that 3,500 number has been reduced based on processing over the past 2 years, right?
Yeah, and that I've taken into consideration in the 3,500, but in theory, it should be it could be even less, which would give more otherwise unused numbers. And China has benefited from the otherwise unused numbers for decades. So each year they get typically several thousand numbers more than their per country limit would normally allow.
Excellent. Thank you. All right. So here's a common question that we're getting.
Yeah, this reserved applicants have the ability to opt out of reserved and opt into unreserved processing. So I think this slide is addressing that issue. The amount of rest of world reserved applicants who opt into unreserved processing would impact the previous slides otherwise unused numbers.
Yeah. So why don't you explain that one more time for everyone who's
Okay.
like me?
My assumption in creation of this chart is to say that there's only 3,500 rest of world applicants that need numbers. But since the reserved applicants have the option to opt into processing in the unreserved category, that 3,500 number could change to 4,000, 4,500, whatever, and make that 6,390 number much less. But that is a great unknown. At this time, there's really absolutely no reason why anybody would need to opt out of reserve processing because all the reserved categories are current, meaning you are going to get processed. People would only need to be opting out of reserved into unreserved when a final action date has been imposed and they can see that their processing in their originally filed for reserve category would face a delay.
So that will likely come into impact more in future years when there are final action dates imposed in the reserve categories.
Right. And one other thing, while we have this up, this process is the same that will be used in the reserved category. So if this was a rural slide, we would go through the same type of math. They'd see what the rural or high unemployment limit is. They would subtract out how many rest of world applicants they have, and then it'd apply to China and India and any other high volume country and figure out if there are otherwise unused numbers available. So again, this is a universal process for both unreserved and reserved.
And really EB2 and EB3, right? I mean,
Yeah.
it's the same concept. It's the same.
Yeah, this is exactly the same thing for any category.
So earlier we were mentioning the 27% rule. Can you give us what that is about and how that impacts, when final action dates may be imposed? And then also give us let's just go with that first for the time being.
Sure. Yeah, the Immigration and Nationality Act guidelines indicate that only 27% of the annual limit should be used in each of the first 3 quarters and the final remaining 19% in the final quarter. Therefore, what we've done here is based on our estimated 4262 annual limit for rural, then that means that 27% of that could be used in the first quarter, October through December, which would be 1151. If when the State Department is determining the December dates, if they do not feel that number use in October and November plus the estimated December use will equal or exceed that, then they should not impose a final action date. If they think that number use will exceed that total, then they would impose a date. So again, then we would move into their timeline for the second quarter, October through March. So up to 54% of the numbers could be used, which would be 2302. If they're going to exceed that amount, they would impose final action dates. If not, they could keep a category current. We move in to the next. And then, like I said, the remaining balance that's used in October through September. But again, this is in theory, assuming the State Department is applying those 27% guidelines, which I would hope they will be using.
And to be clear, this number use is not I-526 petition approvals. This is
Actual, yeah, this is actual visas issued and adjustment of status cases. So it doesn't matter that there's 3,000 people ready, that have filed petitions when they're looking at the first quarter. If they can only issue or adjust status for 500, 700, 800 applicants, then there is no need for a final action date. A final action date would only be imposed if by the end of December, they feel that they would have used 1151 numbers.
right.
And this is why this is why I can say right now that the reserve, both the rural and high unemployment areas, should be current for October and November, because again, October dates are established in early September and the November dates in early October. And at the time the November dates are established, no numbers would have been used.
Okay, you heard it here. And is that for both rural and high unemployment?
And high unemployment. And again, when they're making their estimate in early October, it's very unlikely that they could make an assumption that they're going to use all the available numbers during the month of November to require a date.
Right. And this slide here just shows the same concept with the annual limit all the way to the right and the 27% in the first 3 quarters, and the same holds true. And the thought being, if they're adjudicating, a third of the number of high unemployment cases as rural, well, maybe those numbers are going to exceed in rural faster than high unemployment. That's
Right.
That's the open question.
Yeah, and when you look at that 575 numbers available, this is why in the earlier events, it was kind of assumed, okay, because of the high volume of high unemployment cases that had been filed in relation to this limit, it was reasonable to assume that the high unemployment category would have the first final action date. We're seeing that's not going to happen. So, as you say, I think that high unemployment will have final action dates imposed later than rural.
Fiscal year 2026 final action dates. Um, we're going to be, let's start with some general questions. You've said that the first couple of months in fiscal year 2026 are going to remain current, right? Because what about for the remainder of the year? Do you think we're going to see some sort of final action date in calendar, well, maybe not calendar 2025, but in fiscal year 2026?
I don't believe there will be any dates in the first quarter, which would be October through December. The reason being they would have to use as many numbers in that quarter as they have so far this fiscal year of those that we know about. So I think that that's unlikely, but again, unfortunately, we don't have any historical data to rely on accurate patterns that are happening. So it makes it much more difficult to um, make estimates. And again, as you mentioned earlier, they're not necessarily processing to conclusion the approval or denial of petitions in a first in, first out order. It's kind of all over the map. So whereas in the say for the China employment second preference, we have a lot of pent up demand in priority date order of approved petitions, which makes it relatively easy to make estimates. We don't have that with the reserved.
Right. And so, I mean, what would you say is a like a best case scenario for you?
Again, these will be better than nothing estimates that I'll be providing. I think that in a best case scenario for China, a late fall 2023 date, and India, rural, a late winter 2024 date, and I believe rest of world will be current. For high unemployment, I believe that China would be a winter 2022 date, and India a winter 2023 date. The rest of world a late fall 2023 date. But again, these estimates would be based on them processing cases basically in a priority date order and looking based on when the cases were filed. And that's why I say it's better than nothing, because we're probably not going to see that. They're processing now. We're seeing it all over the base. So I would not put a tremendous amount of emphasis on these dates at this point. They're just a you know a guideline, and they could probably be considered worst case.
Okay, thank you for that.
I would like to preface one thing because I don't want to scare anybody when I gave estimates. And I think that it's remember those estimates are based strictly on the assumption that cases will be processed in a first in, first out priority date order. And we have at this time we have no indication that that will be the actual case.
Thank you. I think for a lot of people who are looking at EB-5 today, the discussions I have, multiple times a day, is people know there's a backlog coming. And they're seeing what's going on in the tech industry. They want a backup plan, and they're okay with these wait times because it's faster than their EB2 and EB3 priority dates still, with their EB2, EB3 priority dates. So the other thing which is very interesting is, this sustainment requirement. Yes, there's going to be rulemaking about that, but the way that USCIS interprets it at this time, and as it says on their website, is like you can get your money back before your I-526 is even approved, as long as it's been invested for the required 2 years. And so I think there is this element of people are looking less at rural versus high unemployment and more about job creation and financial security to get the money back. Because, hey, you're going to be stuck in a backlog no matter what if you're Chinese or Indian, right? So get the job creation, secure the conditions to be removed, and get the money back, and then wait. And if something were to happen, well, hey, you got your EAD as the interim benefit, as the backup plan. And I think that's a good thing for investors to some extent. It's better than having to keep their money at risk for longer. So I think that's a good thing for investors. I also think it kind of extends this whole process with having a conditional green card and then waiting 2 years to remove the conditions is almost a little silly with these backlogs, because all of the job creation should be happening ideally in the next 2 years, right? So all of the documents for the I-29 should be ready potentially before you even get your conditional green card, right? It should be, for some of these people. And so, maybe we need to figure out a way a legislative way to speed up the ability of them to get their permanent green cards. Why have the conditional period if those conditions have already been met? Is kind of my point there. So that's something that maybe we can rally around. I think that's the end of our call today. We do have some questions that I want to get to, but if you guys ever have questions, you can reach out to us here. My email is jbarnett@wolfsdorf.com. Please feel free to reach out to me directly if you want to schedule a time to speak about EB-5. Let's go through some of these questions. If rest of world has a cutoff date for HUA, can rest of world do concurrent filing if they opt out of that high unemployment category? Ooh, that's a good question. So the question is can they file the adjustment of status at the same time? I don't think they can. At the same time that they do the concurrent, I don't think they would be able to do that. I would think the lockbox would reject it and say, well, no, there's not a visa available for these people, even if they later go in the unreserved category. That's my take. We haven't had to deal with it yet. That's a good question. And no, we're not predicting EB3 forecasts. We have a separate webinar with my partner Sharina that Charlie does, which talks about employment-based visa backlogs and forecasts. So please check us out on YouTube there. All right. Well, I thank you guys all for listening in today. The other questions that we had, I think there was something about, it was really just about, do you think there was going to be some sort of final action date, I think in fiscal year or calendar year 2025. And I think the answer is it's very much unlikely to happen. Oh, here's a question. This is a great question. It's from one of my clients who just got 526E approval in under 5 months. Is this an indication that USCIS wants to consume all the would have been wasted visas before September 30th, 2025? I mean, I guess we can give them the benefit of the doubt. I don't think so, because as we've been discussing, they still need to adjudicate the adjustment. So if they adjudicate the adjustments in the next month and we see a big increase of conditional green cards being issued, well, then I would say yes. But I don't think 526E approvals are an indication. Good question. Generally, though, would say it's taking, I don't know, anywhere from 3 to 6 months after the 526E is approved for USCIS to adjudicate the adjustment. For some of these folks who filed, before December of 2024, they didn't have to submit the medicals at the time that they did the adjustment, so they're getting requests for evidence to go get the medicals done. So that is one thing that people could do to sort of get ahead of it, is go get the medicals, the I-693 done now. And when the RFE comes in, you can respond quicker. Or some people are sending them in and on an interfile. I kind of advise against that because they could get lost. But if you get extra copies, I don't think there's anything I don't think there's any downside there.
Joey, one thing that people have, have asked in the past is about the Chart B in the Visa Bulletin. I think it's going to be important for people to note that even once there's a date established in the Chart A final action dates, the Chart B will still govern filing for anybody in the U.S. for adjustment of status for a period of time. So again, that Chart B will be very important to pay attention to, because typically the Immigration Service will allow Chart B to be used until somewhere in the January through March timeframe. So if it continues to say that China, India, everything is current, or even if they establish a Chart B date, you still have the benefit of being able to file based on that Chart B date up until the point that the Immigration Service says, no, we're not going to honor that any longer. So this may be a tremendous benefit for stateside applicants.
Yep, I totally agree with you on that. Do you know if rural area cases get priority at NVC or adjustment of status processing? I have not seen that to date. It's really, it's been what?
Yeah, I would not expect so, because typically, at least when I was in there, cases were processed at NBC in a first in, first out basis. They 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 had the contractor had a requirement to process cases in a certain time frame, and therefore, if they received a high unemployment and rural today, they need to get both of those out the door in a certain amount of time. So they're not going to say, "Oh, we'll do the rural now and wait a couple weeks for the high unemployment." Unfortunately, that does not seem to be the case for USAS petition processing.
Right. Right. At least for the 526Es.
Yeah.
Okay. Well, thank you so very much for everyone who's listening. Please feel free to reach out to us. If you're listening on YouTube, thank you, Charlie. Hope you have a great Labor Day holiday, and we'll see you all next month. Thank you.